you don't want to get to launching your product and then find out after you've launched and you've, set up a domain name and packaging and social media channels, and then it's like, oh, I can't own that name.
Welcome back to the Pitch to Product podcast. Today I'm joined by a special guest, Robert McConnell, patent attorney based out of Los Angeles, California. Robert, it's great to have you here. Thank you for the time. You can introduce yourself.
Yeah, certainly. My name's Robert McConnell. I'm a patent attorney. I'm also I'm an intellectual property attorney, practice particularly in acquiring patent rights and acquiring trademark rights and some other things. Like Jack said, I am based in Los Angeles, but I spent the first about 20 years of my career in Silicon Valley working, with high-tech companies. And so I have and startups. And so I have a wealth of experience with knowing, what to do as a startup and what also maybe not to do. And I like to bring that to my clients, who are generally, individual small and medium-sized businesses that have intellectual property that they want to protect, either patents or trademarks, sometimes copyrights. That's a topic for another day. So yeah, that's me.
Perfect. And you haven't seen me on the channel before. I'm Jack Dalton, business development manager here at 52 Launch. Robert, you've taught me a lot of what I know about intellectual property, so this is going to be fun. Your second time on the channel. Looking forward to getting into it. We're going to cover some basics, maybe some slightly more in-depth topics today, but we'll see where it takes us.
Yeah, I'm excited to have a conversation with you about these topics as well. So let me know where you'd like to get started.
Yeah, well, we can start with a question kind of from my own curiosity. I'm often the one here at 52 Launch who is making introductions between our clients and one of the attorneys that we recommend they work with. And I've never really thought about, what exactly am I sending our clients into? Depending on whether they're getting a trademark or a patent, we can cover both of those. But what are those initial consultations like? If that initial call goes well, what are the subsequent steps? You could just sort of walk me through those early stages with a new client.
Absolutely. So when you send me a client, a potential client, make an email introduction, I often respond, and the first step in the process is to set up an initial consultation, Zoom meeting generally. Though, it could be a phone call or even an in-person meeting if the person is in Los Angeles and wants to meet me in my office. And during that conversation, that initial consultation, I am trying to assess where they are in the process in developing a new product. So we can really keep this to 52 Launch type clients where they've got an idea, they're working on developing this product with you, they want to go to market at some point, and there are questions about their brand and also questions about any patentable inventions they may have come up with in the process. So, I'll schedule a call with them. We will get on the call. I will ask them to give me a high-level description, the elevator pitch for their product, just so I know what we're talking about. And I will also ask them where they are in the process. Sometimes, people are very early in the process of developing their product, and there are things that can be done early in the process, and then there are things that it's better to wait as you're closer to the final product, right? And so, just from a very simple perspective, trademark issues can be dealt with early in the process. Patent issues are better dealt with after the product is mostly developed, so that we understand what we're really dealing with here. And we're trying to determine whether that final product is qualified for patent protection, either because it's patentable subject matter or because It's new or non-obvious, which is some patent language. But let's just say it's an invention and it's something new that can be patented. And then also in terms of actually filing a patent application, we definitely want to try to file a patent application that reflects exactly what the product that's going to be sold will be, so that that can be protected, right? And it's not just maybe the exact embodiment that's going to market, but also trying to build in some leeway so that other variations of it would also be covered by this patent application. And that really only makes sense to do close to product launch. But we can get started on some patent questions earlier in the process. Specifically, what does the prior art landscape look like? What has been out there before in this space? But again, the details are incredibly important, and sometimes what makes the difference between patentability and not patentability are the fine details of a product. And so if they aren't quite developed yet, you don't always get the best answer out of a patentability search. So let's talk a little bit about trademark, because I think it makes sense to sort of talk through the timeline of working with me, or really any intellectual property attorney. I don't think it's going to be too different across the board, but like I mentioned earlier in the process is a good time to investigate trademarks. And just for people who don't know, a trademark covers your brand name and the association between a brand or a design, and there's some other categories of indicators that can be trademarked that are less common, like scents and colors. But the association between that trademark and a particular good or service, or a list of goods or services. And, just think about Starbucks or McDonald's or Google or Apple, Nike. These are all very famous trademarks where, Nike is associated with athletic apparel and shoes. Starbucks is associated with coffee. Apple is with computers and devices like that. And the real value of a trademark is so that a consumer can assess the quality of a product, right? And when you go to Starbucks for coffee, if you've been to Starbucks before, you can be sure you know what you're going to get, right? And the way it's going to taste and what options are available. And that's really the goal of a trademark. But also, from a more basic perspective, that's going to be probably the name of your product, right? And when you go to market, you want to make sure that you have a product name that can be protected and prevent other people from coming along and making some close variation of your name. I'm not very good at making these things up on the fly, but for Starbucks, if it was like Barbucks or Starbucks, like some silly, misspelling in the hopes that you would confuse people into thinking that you're Starbucks, that's trademark infringement. And so you really, like, this is a core piece of intellectual property for any business that goes out to consumers or even brands, but certainly for consumer type goods, having ownership of your name and your brand is of critical importance. And that is a process that can get started at the beginning. And one of the biggest sticking points I have with brand owners is they want their brand name to be very descriptive of what they sell, and tell you exactly what they sell. And that, it turns out, is not allowed in the trademark world. The public policy is, let's not protect things that other brands need to use in describing their products, right? And so there's two categories of trademarks that are difficult to protect at the beginning of a product. One is generic trademark, which is just the actual word for a good or service. Those are never protectable with a registered trademark. Descriptive trademarks are registerable after you show that you've developed secondary meaning, which means it's famous in some way, shape, or form. That is just not possible with a new product. So, really getting into trademarks that are less in those categories is really important, right? So that's the first place, we get into, and the word in trademark practice that's used to describe anything that is, you can register as a trademark is distinctive material, right, versus generic or descriptive. And there's some other categories. I won't get into that. Maybe we could save that for another time. But the two big tests at the beginning of a trademark process with a new client are: is this name descriptive of the goods and services? Either it's a generic word that just is like the word for something, or the trademark describes a characteristic ingredient. There's a list of words that just that go along with descriptiveness, and it's okay to have a combination of descriptive terms with distinctive terms, but there's got to be something in there that's not
Right.
descriptive or generic. So that's one, and then the other is the question of likelihood of confusion. Is there another trademark that's already registered that's similar for similar goods or services? And this is my job at the beginning of the process, is to determine if we have issues with either of those things. And descriptiveness, I generally can identify just without doing too much work. I need to understand what the product is, and I might have to do a couple Google searches. But I'll typically ask the client, is this a characteristic or ingredient, or some way descriptive of your goods or services? And then the other is the likelihood of confusion, and that's a search, right? So I need to go look in the trademark office's database, see what's been registered, what's been filed before, and determine if there's a likelihood of confusion. And that is that. So, as we're working together, so we have this initial consultation. We talk about trademarks. Client says, I feel good about this. I'd like to hire you. There's an engagement letter, a deposit that is equal to the initial, the projected initial legal and filing fees. And then I get started. And, for a trademark project, the first output is a trademark search report.
Right.
And, that's an email with a PDF attached to it. It has all the trademarks I found that I think are somewhat similar, ranked by whether they're too close, in the middle, or no big deal, and a recommendation about filing. And then, I work with the client to collect the information that's necessary for the trademark application, which is really, the final trademark, the goods and services, the address that the client is going to put on their trademark application. This is a public record. If you list your home address, you will get junk mail that looks like you need to do something and send money, which you should never ever do. The trademark office doesn't communicate with applicants via postal mail. They only communicate with attorney of record via email. So, the other thing that we have to figure out is who is going to be the owner of the trademark. Is it the person individually, or is it a company or entity that they've formed to do business?
Right.
Then there's the filing status, right? And you have to tell the trademark office, I'm using this trademark in commerce with the goods that are listed. And if you say that you're using it, you have to show proof that you're using it, which is called a specimen. And that is generally a photo of the trademark on the packaging or a website with the goods or services that are listed. But for most clients working with you guys, their filing is intent to use, right? Because they haven't actually started to use it yet. And they just, I have the intention of using this in the future. Let's do the examination process. And when we get toward the when the trademark is allowed, and I'm start to use it, then I'll show you that I'm using it and we can register the trademark. So the entity is important to that. And, we could take a second and go down the rabbit hole of entities right now if you'd like, or we could save it for
Absolutely. I had
later.
one question I wanted to ask
Sure.
before we did that. I think that'd be a great thing to cover. But
Yep.
there are some pretty prominent business people, investors who really strongly recommend the more descriptive names for your business. And clearly that's not trademarkable. But I'm wondering, would you ever advise somebody to use a descriptive name, even if it can't be trademarked, because it makes it so much more clear what the product or service is, that, and maybe it's something really niche, but there's definitely this idea that, I'm not sure how many people have this idea, but that if you're going to name your business, it should be obvious what your business does from the name. And so I'm wondering, is that ever something that you would advise? Is it even allowed? And if so, can you get any common law rights with a descriptive name?
So let me counter that point with, I want you to think about the trademarks that I just described that are extremely strong, valuable trademarks. Starbucks, Google, Apple, Nike, Rolex, Lexus. Think about those trademarks, and those are not descriptive at all.
Right.
And they fall into the categories toward the far end of the other end of the trademark spectrum, which is, words that aren't connected, that aren't even in the dictionary, right? And then words that have no association at all with the goods or services. So the strongest trademarks are always those that are the least descriptive. And there is a tension, right? And so, but, it's not my role to say, don't do this. My role is to say, okay, well, what can we do to protect you as much as possible? If you're really in love with this name, there are some things that we can do. And there are two approaches. One is you can come up with a logo with your descriptive trademark in it. And this may not work for generic trademarks. So let's just assume it's descriptive and not really just generic. And the logo can have some distinctive design elements with it. And that logo can then potentially still get registered as a trademark because it has distinctive matter in it. You still have some issues, which is the literal element of the words are descriptive, but you can get a registration. And the issue with logo trademarks is that when you rebrand, which happens often for consumer products, you have to file a new trademark application. You can't change the way the logo looks on the existing registration. So that's one approach. The other approach is there is something called the supplemental register, which is available for trademarks that are descriptive. And it doesn't help you with infringement necessarily, but it will help you with ownership and examination in the future. So if you register something on the supplemental register, the trademark office will examine new applications against that one and should not issue a confusingly similar registration that's filed after yours. Now, the supplemental register it's sort of like a placeholder. And then if you are successful and you invest a lot in advertising and consumers become aware of your trademark and it develops what's called secondary meaning, then you can go back and register your descriptive trademark as having secondary meaning and then eligible for registration. The problem with all of these approaches is that they are weaker than coming up with a strong trademark. And for brand owners, it may not be important if you intend to operate your brand forever, right? But if you are hoping that you're going to develop a product
Right.
and it's going to be successful, and then a bigger brand's going to come along and buy you out, you really want to have the best assets you possibly can have, right? And so one of the things they're going to examine first off in any sort of acquisition is, what's your intellectual property? What do you own? Do you own your name? And if you don't own your name, it's really hard. And if you've developed a bunch of brand recognition behind a name that you don't own on paper in the US Trademark Office, or in other countries where you're operating, it's not great. So you can develop common law rights. They are bound by what's descriptive and generic as well, how strong they are and how much you can exclude other people from using them. I wouldn't recommend common law rights as an approach. I mean, you really end up in state court and litigation versus federal court. You have to prove that you own the name. There's geographic limits. I mean, it's not as great as having the bundle of rights that come along with the federal trademark registration.
Yeah. Yeah, that sounds less than ideal.
Yeah. So that's a lot of words. Yeah. So, I mean, and I'd be curious to know which big investors are trying to push product owners or brand owners towards descriptive trademarks, because I just don't think that's very good advice.
Yeah. Yeah, there's one on Shark Tank. Not even sure if they're still on the show, but I've heard the advice before that, I have no idea what your product is from the name, and turns out, as you said, that's not great advice.
Yeah.
The strongest brand
Well,
names are kind of out there a lot of the time.
yeah, right. I mean, just like the word Xerox, which is, I guess it's an old brand now, but or Kodak. Those are words that aren't in the dictionary, right? Starbucks isn't in the dictionary, although I think it's a character in Moby Dick. But anyway, I just think it's another approach is, and this is what I often recommend, is come up with one word that is distinctive, suggestive, subject to trademark registration, and then you can put another descriptive word with it and you can still get that registered. So that's a way of coming up with something that is registerable, that doesn't have the same problem, right? And
Right.
that's the tension, the balancing act, right, is coming up with some of both.
Yeah, absolutely.
Because I understand from a new product perspective, selling a product that has a made up name is like, that you have to put more effort into marketing and educating consumers about what your product is. And let's just not forget that coming up with a made up name is hard. I mean,
Right.
it's really hard. And I'm personally not great at it. And I have clients that come to me and I say, "Oh, you could make up a word," but I don't know how to tell you how to do that. So
Yeah. Yeah. Haagen-Dazs.
it takes a lot of guts to sort of say, you know what, I'm going to name my new product Google,
Right.
right?
Right.
Um,
And it almost seems like it's easier than ever now, especially in the product space, to use a name that's less descriptive and more just, what's the word for it?
well,
Arbitrary?
distinctive. Well,
Distinctive?
there's three categories uh, of on this. There's a 5-part spectrum of trademark protectability, and generic and descriptive are the first two categories, and then suggestive, um, arbitrary, and fanciful are the
Fanciful.
next three. So suggestive means that it requires a leap of imagination for the consumer to get from the trademark to the goods or services. That's the legal standard. Good luck understanding what that means. There's a lot of law that people argue a great deal about it because it's on the line. And then, arbitrary means it's a word that has no association with the goods or services. The example I always like to present here is Apple computer, right? If you named your your delicious Washington grown apple variety red apple, never ever going to get trademarked. You name your computer Apple computer, it's an arbitrary trademark. So
Or your gas
you know
station,
that
Big Apple.
Right, right. In there, that one's got a potential issue, legal issue with it, which is there are some questions about geographic identifiers, right? And so
Oh yeah.
if you, yeah, yeah. So anyway, but if you just called it Apple gas station, it would you probably get a letter from Apple Computer, but you could probably get it. Wouldn't have a problem with descriptiveness. And then the last is fanciful, which is it's just a made up word. Yeah.
Yeah,
Or
that's
maybe I've
interesting.
mixed. I think I mixed it up. It's fanciful then arbitrary. Arbitrary is the made up word. Fanciful is the one that doesn't associate with.
Hmm.
Yeah. Anyway,
Either way,
um,
it would seem like, especially in the product space, it's easier to use those types of names now than it was in the past, because at least for 52 launch products,
mhm,
most of the time a new consumer is finding a product, they're seeing a picture of it or a video as soon as they're seeing the name for the first time. So there's no
yep,
confusion about what the product is or what it does.
right,
It's just accompanied by an interesting out there name.
right. And you're probably having a conversation with the consumer on social media. I mean, I
Right.
think that's probably the first place that many people um, encounter a new product today is on social media.
Hmm.
Um, and so there's really an opportunity to explain what the product is with the name. But yeah, I mean, it's just one of the areas where there's a lot of, um, I have to do some education with clients. There's attention that's just built into the system. And, it's my job to help people figure out where to be on the spectrum, you know, um, and how to avoid the problem, which is, for a new business, let's say someone's working with 52 launch, they are 6 months out from their product launch, right? And they come to me and they want to get a trademark for their new product name. When we file that trademark application, we want to have a high level of confidence that that is going to go through and be allowed, because it takes currently 4, 5, 6 months for the trademark office to examine an application. And you don't want to get to launching your product and then find out after you've launched and you've you know set up a domain name and packaging and social media channels, and then it's like, oh, I can't own that name. And so I tend to really recommend, especially if you're an individual or small business, it's not great to be right on the line, because you can't
Yeah.
always, there's human beings on the other side of the process deciding, and the legal standards are very broad and vague, and it's sometimes hard to determine if something that's on the line will go through or not.
Yeah, and that's one of the reasons we generally prefer to send clients to an attorney to at the very least have a conversation rather than having them file trademarks themselves, which is a question we've gotten a lot more recently with the rise of AI tools around these filing processes.
Hmm.
It's, because filing a trademark isn't necessarily the most complicated process in the world, but if you don't do the search right,
Yep.
then you spend some time and effort and money filing, and then 6, maybe 7 months go by, and then you get hit with the what you were just talking about. Oh, you can't own this brand name, and all the meantime, you've been building a brand around it. You've been producing content, packaging, maybe putting the name on the product. So it can be a pretty legitimate setback if that doesn't get approved.
It can be, and AI is very tempting to help. And I've had the situation where a client has sent me a report that looked like a lawyer generated it, but it came from AI, and it was also incorrect. Right? It had hallucinated some things, and it's just risky at this point. So let me tell you what happens if it looks like you could file a trademark application yourself. It's fairly straightforward and easy to do it. The trademark office has recently upgraded their systems so they're a little more modern and look more like a real website versus,
Right.
something from the 90s. And so it seems like it could be easy to do. And it's really, one of my favorite legal terms is attractive nuisance, which, the example they give you from law school is the empty swimming pool without a fence around it, right? So some child's going to run into the empty swimming pool and get injured or get trapped. And I think that the ability to file trademark applications without an attorney is an attractive nuisance, because what
Mm.
ends up happening is there is a chance that it could go through, right? Um, and especially with an intent to use application, you could get a notice of allowance, and then it says, okay, you have to file a specimen within 6 months, and then you say, well, what's a specimen? And more times than not, I mean, of course, I only get clients that come to me after the process didn't work,
Right.
but they filed a specimen that's wrong, and they somehow managed to and you can get to a place where the application is just dead and it gets abandoned and you can't fix it with that. And then the other thing that could happen is you get a rejection, and it says, oh, your trademark's descriptive, or there's a likelihood of confusion, or your identification of goods or services is incorrect. Your There's a variety of rejections, and for non-lawyers to try to read them and understand what they mean it's hard, right? And so then they come to me, and I would say a lot of times you're left in a couple of different places: a corner where the only real approach is to start over, right, and lose the money you've spent, and hire me to do it from scratch from the beginning. But then you also lose the priority date that you originally had, and so that's an issue. The other thing that can happen is, it costs more money to fix it than it would have cost to just do it right from in the first place, right? So I do these things on a flat rate. I know what I'm doing. Um, you know, it. I'm not going to say never ever is there any additional cost, but for the most part, trademark applications that I file, um, don't get rejected for a likelihood of confusion or descriptiveness.
Right.
I'm not 100%, but it's you know it's a smaller number, right? And um, so I just think you end up in a corner where you can't get out of it, and it's also really confusing for non-lawyers. And I'll be honest, it's also confusing for non-trademark lawyers. So I've had lawyers come to me that have tried to do this on their own and gotten in a corner, and they need help getting out of it. And so, um, and AI is a really strong tool, but I don't think it's there yet. And
I would agree.
I don't use it for anything that has any legal impact in my business. And it's something that lawyers are keeping a very close eye on, but it's just not there. So yeah.
Yeah. Yeah, absolutely.
So that's the horror story that can happen, and it's I never like to have to say, oh yeah, it's going to cost more to fix it than it did to just do it right from in the first
Mm.
place.
Yes.
Yeah.
Yeah,
Yeah.
those are unfortunate
And then you have
consequences.
someone helping you along the way who just deals with all the communication and just gives you updates. And so that leads me to the next question that you were interested in, is what does it look like as we go along? So with a trademark, uh, 5 to 6 months in, we can expect to get our first communication from the trademark office. I will evaluate that, put it on my docket, figure out what needs to be done, if anything. And I communicate that to the client. And these days, because of the way that the application process is, more often than not, the first communication is a notice of publication, where it's just been approved for publication, which is, there's a 30-day opposition period where someone who
Yeah.
thinks that they might be injured by the trademark being registered can file an opposition. This is typically just, in my experience, it's big, rich brands that are trying to bully smaller people out of the space.
Mm.
Um, And
So they have
that
somebody on their team that monitors that list all the time.
absolutely, yeah, they have software that says you should look at this one, and that just does that. But that opposition process, another good example is if we do a search and there's a whole family of trademarks from a big brand that is somewhat close, I usually say, well, you might not get a rejection from the trademark office, but you might get an opposition from this brand, and we can look a little bit more in depth to see if they have a history of being that kind of a bully. But sometimes you just don't want to take the risk, and
Right.
new brand owners don't want to get into an opposition situation.
Yeah.
It's too
Yeah.
expensive.
Absolutely not.
No, no. Um, so anyway, that's the process, and then there'll be a notice of allowance, and I walk through people. Hopefully, there's a notice of allowance, and I'll walk the client through what we need to do to get that registered, and hopefully they're down the process of launching, and we can get it done pretty quickly. So
Right.
that's sort of the trademark process. Let's see, what else did we want to talk about here?
We're going to touch
Entities
on
or
entities. Yeah.
patents? Okay, so entities. Let's start with the big headline, which is, having a corporate entity when you're selling a consumer product can be a good shield against personal liability for problems with the product, right? So if you're selling a widget that you've developed with 52 launch and it's amazing, but someone does something stupid and they get injured, and then they get a personal injury lawyer to file a lawsuit against you. If you were selling that product as John Smith or Jane Doe, they could sue you personally for their product liability, and then maybe they're going to come after your bank account or the equity in your house, or there's rules about what they can get or not get, but they can come after your personal assets. So if you set up a corporation or an LLC that actually sells the product, and you follow the rules of corporations and LLCs, which is, you don't commingle your funds, you don't use it as your personal piggy bank, you have a board, you keep the records you need to keep. Then if somebody sues you for product liability, they're suing the corporation or the LLC, and they can't access your personal assets, to pay a judgment. And that could be very valuable if you have a lot of personal assets. So that's the reason to form an entity. But when it comes to trademark practice, you have to decide, especially when you file an intent to use application, who the owner of the trademark application is going to be. And it cannot be changed until the trademark registers for an intent to use application. But, it is possible to assign it if the trademark registers to your corporation. And so sometimes it makes sense to decide whether you want to form that entity at the time you file the trademark application, because you're going to need it. Other times it makes sense to delay and just worry about moving it later. It's not an expensive process to move it later.
Right.
But from a corporate entity standpoint, sometimes doing that too early can cost you more money, right? So in California, where I'm licensed, if you form a corporation or LLC, there's an $800 a year minimum corporate tax, no matter how much your company makes. Delaware has a lower, but you have to pay a yearly tax, and I think the minimum is lower, but there's still a tax. And so, if you think you're going to get to the end of the product process and maybe you're not going to finish it, whatever, it might make sense to just delay. But it's a question that comes up, and that's one of the questions I have to answer before I can file the application: is who's going to own this?
Right.
The same is true for patents, but the process is a little different, so it's not as critical to make a decision, because typically the assignment of patents doesn't happen until the patent's about to issue, if
Right.
it does issue. So anyway, that's just something to be aware of and think about as you're going through this process. It's something that a good attorney can help you decide. It's also something that a tax person can really weigh in on, because there are a lot of tax implications around corporations and having them. And, there is sort of a minimum level of income that makes sense for, from a tax perspective, but you're looking at the liability shield also. So if you're going to start selling products on Amazon, especially if there's a chance that somebody will get injured, or maybe a product will be defective, it does make sense to form an LLC or a corporation.
Yeah.
I
Yeah.
think for
From
most
a
people.
from a business strategy standpoint, our feeling is that it pretty much always makes sense to have some sort of corporation, because when you're writing a business plan, one of the thoughts that should be somewhere in the back of your head, even if you're in love with the idea, is the possibility of an exit somewhere down the line. And certainly any sort of corporate setup will be helpful in a successful exit, rather than having everything under your own name.
Absolutely. And it's just another aspect of wrapping this all up into a nice package that can be sold for a big, huge check, right? And that's I don't think it's every inventor's dream, but I would say that, finding a way to get some big brand to buy your product is great, right? Most people are
Right.
hoping to have that happen. And the more you could do to set it up right from the beginning, the better.
Right.
So, yeah. Well, let's see. Do you want to talk a little bit about patents,
We
or
might as well.
okay? All right. Well, we don't have that much time left, but I can go over if you want. Uh, but so patents, I think are, as I mentioned at the beginning, it's better to get started on that a little later in the process. Once the product is finalized, and a consultation for me for a patent is I'm going to ask you about your product. I'm going to tell you about my services. We're going to talk about strategy, because there's a couple different approaches that I think work for new products. And if you like my ideas and you hire me, engagement letter deposit. Um, and there, you know, and that, at the consultation stage, I don't necessarily need to have every single detail of the product to talk about it, right? One of the first things I'm going to look at is this patentable subject matter. Some things in the software world are not patentable subject matter anymore, and so I'm looking for that. But if it's a widget or a device, a physical product, it's almost always something that is subject to the Patent Act. Whether
Mm-hmm.
it's new or not, that's a different question. But uh, you know, if you hire me, then we'll have a full disclosure meeting. And for me, if I can get drawings from a product person, or a video or photos, and just an explanation from, the inventor of how it works, that's usually enough for me to get started. And, there's two paths that we might take here for a new product. One is provisional patent application first. And, a provisional patent application is kind of a placeholder patent application, where it's not subject to the same formality requirements that the non-provisional is subject to. And, it doesn't get examined by the patent office, but it saves your priority date, your filing date. And then you have 1 year from the date you file your provisional patent application to file a non-provisional patent application. I think it's really important to say right here that a provisional patent application doesn't give you any patent rights. It doesn't allow you to exclude anyone from making, using, and selling the patented invention in the United States. In fact, no patent application gives you those rights. Those come after you have an issued patent. It's
Right.
been examined. But you can say, when you have a provisional patent application, that you're patent pending. And the other thing is that if you go out to third parties to talk about your product, you have the benefit of the fact that your invention is in the patent office with a filing date on it. And so if they come along and try to file a patent application after you, in theory, they should not be able to do that. There's lots of things that we can do in that process to try to prevent that from happening. It has those benefits. The big, I'd say, downside of the provisional patent application is it's just dead time, right? So your application's not getting examined. The patent office is notoriously slow examining applications. So if you take your whole year, you've just added a year to the examination process, right? And so you could be waiting then 3 years before you know whether you have a patent or not. And as we know, that's a long time in our world. So you could be waiting less time. I do see things go faster sometimes, but I'd say the average time to get a first office action in the patent office is about 18 months for a non-provisional. So anytime you're in the provisional stage, you're just basically waiting with nothing happening. One of the benefits of getting the provisional on file is, and this is maybe not as important when you're working with a product company like 52 Launch, is that you've got your idea in the patent office. And so if you have to go out and talk to manufacturers or developers or people where you want to talk about your invention and not be afraid that they're going to steal it, this is a common fear of inventors. You've got this document that establishes that you had the invention as of a certain date. Just goes, I just think it's worth saying at this point for anybody, you shouldn't talk to companies that you don't trust. You have to build up some trust. And also, if you have an invention and you're talking to a third party, you should always do that under a non-disclosure agreement. And, that's just a contract though. So it's important to work with vetted companies that you trust. So anyway, that's so the provisional first, then you file a non-provisional when the product is final. You can add new matter to the non-provisional. It will have the filing date of the non-provisional application, but we can take everything we've learned in the product development process and add it to the final patent application. So that's one thing. And I usually recommend between the provisional and the non-provisional doing a pre-filing patentability search to look at what the prior art is that's already been patented or filed applications. And that's for two reasons. Sometimes it's just an absolutely don't go forward. You're going to waste your time and money. You're blocked. This is already out there. That tends to happen for simple inventions. That's where that comes up. For more likely than not, it's going to help us craft the invention, the application to try to claim the right breadth of invention to get allowed, and to know if there's additional features that need to be added. So the other approach is to do the patentability search at the beginning before you file any applications. That I tend to recommend if it's a simpler invention. If we think that there's an issue with potentially prior art, then you have a sense of whether you have something that you can get patent rights on, and if it makes business sense to go forward, right? Even for the simplest invention, sometimes you can get some sort of patent rights, but especially in the utility world, sometimes those are of little or no value because you could make one small change to a narrow patented product and avoid the patent altogether. So, that's a business decision that has to be made because you could easily spend 10, $12,000 getting a utility patent issued, and it may not be worth it.
Yeah.
So, you know, let's just talk about the process. So once you engage me, we do the disclosure, we decide the strategy. Then you're going to start getting deliverables from me, and either it's going to be a drafted patent application, whether it's provisional or non-provisional, or a search report that says, "Here's what I found out in the world." Um, just will note that there's a huge number of uncommercialized issued patents and filed patent applications. So there's a lot of prior art. And just because there's not a product on the market doesn't mean that somebody didn't think that they were going to sell a product at some point. So we often learn some interesting things. In the US alone, right now, there are 13 million plus issued patents, utility patents. And then there's many more published applications. And then if you start to look worldwide, I pulled some data up on this a while ago. I think there's well over, I think it was like 1.4, 1.5 million applications filed every year in worldwide. I mean, it's just a lot of patent applications. So,
Yeah.
you just have to be aware that just because you don't see it on the market doesn't mean that it hasn't been tried before. So it's just important to go into the process with the right information. So you get some deliverables from me. Let's say, for example, it's a patent application. We review that together, decide if it's ready to get filed, and then there's some additional forms that have to go along with it that are boring to talk about, but I will handle. And we'll file the application. And if it's a provisional, I'm going to keep you up to date on, how much longer you have in your window. And I'm going to send you periodic emails and say, hey, 6 months,
Yep.
you've got 3 months left, a month. It's time to really get going on this. And then if it's non-provisional patent application, there's going to be some communication from the patent office, also like filing receipt. I will file something called an information disclosure statement if I find any patents in the process, the patentability search process. We have both the inventor and myself as a registered patent attorney have a duty of candor and disclosure to the patent office. So if we know of prior art that we think is relevant to the examination, we have to report it. So I do that if I've gotten something from the inventor or if I found something. And then we wait.
Yeah.
We wait for
While.
a year and a half. And then if there's an office action, I'm going to look at the office action. I should say, I'm hoping that there's going to be an office action,
Right.
because if I get a first action allowance, it means I didn't ask for enough. We could have asked for more potentially, because it's really a negotiation on the claims, what you're getting in this application. And you want to start with asking for more than you're entitled to. You're supposed to ask for what you're entitled to, the law says. But you want to make sure that you're asking. Yeah. But it's a negotiation. So, get an office action. I will discuss it with the client. Some of them don't need the client to respond. Some of them do. And, I handle that process for them. And some other things that might happen along the way is there are deadlines for international patent filing that I'm going to let you know about. And I'll let you know about different approaches for international patentability. It's typically 1 year from the date of filing of the application, to file internationally and claim priority. I think it's a topic for an entire hour conversation about international patents, but that's something that I'll remind you about as we go along. And and basically the advantage of having a patent attorney do this is that most of the communication you get from the patent office on the patent side is completely impenetrable for a non-patent attorney. And that my job is to be a translation layer and say, this is what this means, and this is what we have to do. And that's what I do along the way. So that's kind of the thumbnail sketch. Some things that I also need generally for a patent application, that I think 52 Launch generally develops as part of their process is drawings, black and white line drawings for a utility or design patent application. And typically your designers have already developed that, so I can use that if I need to hire a draftsman. My draftsman can do it if we need to get him involved. And yeah, that's about it. Let's talk about the on sale bar really quickly, which is the deadline to file a patent application. Based on an invention. So if you have 1 year from the date of first offer for sale, public disclosure, or inclusion in a printed publication to file a patent application for a particular invention. So typically, it's better not to come up on that deadline. You might arrive there by talking about somebody that you're talking to someone and offering it to them for sale, right? But that deadline is really hard to get around, and it is not going to be an issue in the examination process. The patent office doesn't ask about it, right? They don't say, "Oh, you've disclosed this." You're technically supposed to disclose it to them because it's relevant to the patentability. But where that really comes up is in the situation where you've developed a strong business that's covered by a patent, and then someone starts infringing your patent. You go out, sue them in federal court for patent litigation, and then you have to give every document that you've ever written about the invention that's not privileged or confidential to the other side. And you could just be sure they're going to find it and make an issue out of it. So typically when I work with,
void the patent,
it makes the patent, it can make the patent unenforceable. Yeah. And not only that, you can spend hundreds of thousands of dollars fighting on the issue and then lose the issue and be really mad that you built a business. Yeah. So it's better not to get in this place. When I work with 52 Launch clients, typically they haven't really gone out into the market. And my sort of best practice is, let's get something on file, whether it's provisional or non-provisional, in the patent office before you're out selling the product or offering it for sale or putting it on a website. And then you just don't have to worry about that on sale bar issue.
Right.
Yeah. So let's see. I want to talk about one last thing that I think is really a great option, is design patent protection, right? So we talk a lot about utility patent protection, which covers the function, the way something works. But there's another option, which is design patent, and it covers the ornamental features of a useful article of manufacture. And I think design patents are great for consumer products, especially for consumer products that are kind of not new. They aren't necessarily entitled to utility patent protection, but if they have a cool design to them, the way it looks, you can file a design patent application, and they're not as popular, but it's a great backup. And they work a little bit like trademarks in that if an ordinary observer was to look at the accused device, the one that is similar to the patented device, and think that they were the same device, then the patent's infringed, right? And so that can be very valuable for somebody who's selling a consumer product. And The other thing about design patent applications is they're less expensive. It's a less complicated application. The filing fees are lower. There's
Right.
no maintenance fees.
Oh, I didn't know that.
Of course, for the life of the patent, utility patents have the increasing maintenance fees over the life of the patent, and there's some advantages, right? And so you could have both utility and design patent protection, or you could have one or the other. And it's just something that I've been recommending to my clients in situations where maybe utility patent protection isn't appropriate.
Yeah. Yeah, absolutely.
Yeah, especially in the consumer products world, um,
Yes.
where the way things look is really critical. And, it's really easy for, Chinese manufacturers on Amazon to just make copies, and sell them. And yeah, and just as a side note, when you're talking about an ecosystem like Amazon, patents are extremely valuable, and it's much lower cost and easier to get people kicked off of Amazon for patent infringement than it is to go to court and file a patent infringement lawsuit. And so that's one of the big benefits. And I mean, who's not selling on Amazon? You can't sell a consumer product not on Amazon, right?
Right.
I mean,
It's crazy. I mean, it's
yeah.
it's unbelievable. Whether people consult with you or us first, it's interesting that those conversations are going to be very similar. It's a
Mhm.
lot. We ask a lot of the same questions that you do in our initial consultations, and obviously, that makes sense because we're working with a lot of the same people. Almost everybody that works with 52 Launch works with an IP attorney, not necessarily vice versa, but there's some overlap there. And it starts the same place with us needing to understand the product, what the end design is going to look like, what is the business plan. But then obviously we go in such different directions, and even meeting two is so different, I would assume. But yeah, I think you touched on a lot of the basics, covered some of the nooks and crannies of this stuff. But no
For
questions on my
me,
end.
just on the business aspects of IP law. So it's not really my role to look at someone's business plan or product and say, "Oh, I don't know if this is going to work," right? Um, it's their dream, it's their idea, it's their responsibility to go forward and make it work, right? And I am not in the business of crushing people's dreams by saying, "I don't think this is a great idea." Um,
Yeah.
I will tell people when I think it is a great idea, because but but it is my job to sort of say there's a balancing act, right? And, there are very few people who are wealthy enough to just do everything to make, market,
Right.
protect a product, right? And so it's really a lot, there's really an investment balancing act. And I don't want to have them earmark too much of their initial capital to IP attorneys, right? So it's really about doing what needs to be done at the right stages, and and sometimes putting off decisions until you really determine if there's a market for your product, right? And
Mm-hmm.
sometimes you might even launch a product that seems like it's going to work and then it doesn't, but you learn something in that launch and you change the product and then that one's successful. And so, it's just really, it's important not to spend all the money doing every single protection strategy.
Yeah.
But then there are deadlines that come along and they just can't be
Right.
undone.
Right. To go
And
back to
so,
disclosure, the longer you can wait before disclosing your product, the better, because then you give yourself that full year from sale to go through that cycle, to fail fast, and then to
mhm,
do it right the next time without
yep.
having invested potentially tens of thousands of dollars in intellectual property.
Mhm.
So certainly
It's
it's our
just, it's,
preference when clients come to us and they haven't really put their idea out into the world yet.
mhm,
They're
mhm,
super early. Maybe they just had the idea over the weekend when they were looking for some widget on Amazon that they needed to do something around
mhm,
the house and
mhm.
discovered that it doesn't exist. Like,
Yeah.
yeah, people want all the market research in the world. They want to hear 10,000 people tell them, yes, I would buy this, I would pay this much, but it's all those yeses is not as powerful as one person actually handing you cash for
Mhm.
your offered good or service. And
Right.
yeah, it's why we try to get people to market into revenue as just as quickly as we can,
Mhm.
put an MVP out there, sell it, get some revenue going before you start working on the V2 and the V3. But yeah,
People I mean, inventors get very excited, and I, I want to do everything I can to encourage, um, someone, an inventor or a business owner. They are their best advocate. They're the product evangelist. These are the people that go out and make these things happen. And it's not my job to, I want to build them up, but also sometimes the reality set in of the situation, right? And so we just want to put people in a position where they can be as nimble as possible during the process,
absolutely.
um, and not have to. One of the things that I have happen all the time, and I'll finish with this is, what should I do if I've gone down this process and I've either kind of come on a roadblock in the IP process or the product process, but I've already spent all this money, and there's this sunk cost fallacy, and it
It's strong.
the right answer is almost always cut your losses and move on, but no one wants to hear that, and it's really a challenge, and not everything's a success. So but really, my job is to just take someone's dream and try to do the best I can to protect it.
Yeah, we feel the
Yeah.
same way.
Mhm.
Absolutely. Well, if you've made it this far in the episode, thank you. Uh, I I hope you've learned something.
Yeah.
And if anybody listening has a product idea that even they just like to talk to somebody about in a confidential setting, feel
Yeah.
free to book a call with us, with Robert. Those,
It,
we have an NDA built into our intake form where you set up a time to talk, and we'll talk about your idea with you for an hour. And even if you don't end up working with us, we might be able to give you some advice. Robert can
mhm.
certainly do the same.
And if you come to my website, mcconnellfirm.com, it's easy to book an initial consultation right there on the website. And,
Yes.
just in case you didn't know this, um, I have a very strict duty of confidentiality and attorney-client privilege. And so you can tell me it's much stronger than an NDA. And, anything that you talk to an IP attorney about is covered by the attorney-client privilege. And that's a good reason to talk to an IP attorney, because when you don't have that, it's all discoverable in the future. And
Yes.
yeah, yeah. All right. Well, thanks,
Awesome.
Jack, for asking me to do this. It's good to see you as always, and I'm happy to do it again whenever you come up with the next. We have lots to talk about.
Yes, we do. Well, we will certainly
All right.
have you back. Very much appreciate the time. Uh, Robert actually coaches the 52 launch team up on some intellectual property stuff. So he's a great resource if you're looking for an attorney. Awesome. Have a good day, Robert. Thank you again.
Thanks, Jack. You too.
I'll talk to you
Take
soon.
care.